My name is Michael Fallings. I am a managing partner at our Austin, Texas office. I focus my practice in federal labor and employment matters, including topics that we're going to discuss today as far as reasonable accommodations for telework. As you can see on the screen, there's more information about my bio, which discusses that I represent individuals and EEOC cases and Merit System Protection Board cases and all types of federal labor and employment matters. I'll be presenting here today. Quick disclaimer, before we begin, this is an informational presentation. It's not supposed to be specific to any specific facts of your case. My goal here today is to provide information regarding the topics I'll be discussing, but you should not accept this as specific advice for your legal case. As far as the topics we'll be discussing today, we will be discussing seeking telework as a reasonable accommodation for a disability. First, we'll be discussing the disability laws applicable to the federal government, what a disability means, the definition for a disability. Then we'll get into how to request a reasonable accommodation, the reasonable accommodation process, the essential job function analysis, and the undue hardship analysis. We'll also talk about the interactive process for a reasonable accommodation. We'll talk about requests for medical documentation that employees receive from their employers. We'll also talk about alternative accommodations, and then we'll talk about challenging reasonable accommodation decisions. And each of these topics, try to focus on the specific accommodation of seeking telework. Of course, there are other accommodations that employees may seek, but we'll try to focus the topics on seeking telework as a reasonable accommodation. So for disability laws applicable to the federal government, there is the Rehabilitation Act, of 1973. This is the law that prohibits discrimination against individuals with disabilities in the federal government. This specifically applies to the federal government. The Americans with Disabilities Act applies to private sector employers and actually has a carve out that says that it does not apply to the federal government employees. So it's important to know the Rehabilitation Act is the law that applies. However, the Americans with Disabilities Act has been amended several times, and those amendments have been incorporated into the Rehabilitation Act, which apply to the federal government. There is also the Genetic Information Non-Discrimination Act of 2008. This law applies to federal government employees and protects individuals from employment discrimination on the basis of genetic information. So these are the laws that federal government agencies are reviewing and considering when evaluating reasonable accommodation requests for telework. And these are the laws that federal agencies must adhere to when deciding upon a reasonable accommodation request. Now, a disability. To obtain a reasonable accommodation, you must prove that you have a disability. And there is a legal definition of a disability. A disability is specifically defined as a physical or mental impairment that substantially limits one or more major life activities, or a record of such impairment, or being regarded as having such an impairment. So what does that mean? So a physical or mental impairment is an impairment that impacts an individual's major life activities such as walking, breathing, standing, sitting for that individual. And it's an actual impairment or condition or something that's physical or mental that's impacting an individual's ability to perform a major life function. A record of such impairment is having such impairment within the agency's records. where the agency has a record that perhaps you're a disabled veteran, or you're a Schedule A employee where you've applied and were designated as having a disability. So there's a record in the agency's records of you having such impairment. The other part of definition is being regarded as having such impairment. So this is interesting. This is when an agency, perhaps a supervisor, considers an employee to have an impairment, even if that employee doesn't even actually have a disability. A supervisor may consider or may believe, even mistakenly, that an employee has a disability. Well, that employee could still meet the definition of a disability, even if there isn't a diagnosis there, if the agency believes that or regards as the employee as having a specific disability. In addition to proving you have a disability, to obtain a reasonable accommodation for telework, you also must prove that you're a qualified individual with a disability. And then the law defines qualified individual with a disability as a person to an individual with a disability who, with or without a reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. So we'll get into essential functions in a little bit, but that basically means that the person must be able to perform their job even without a reasonable accommodation. So to be qualified for a reasonable accommodation. Um, the purpose of a reasonable accommodation is to assist the employee in performing their job. But to be qualified, you must prove, often through how you're performing, whether you can perform the essential functions of your job without a reasonable accommodation. So the next slide is how to request a reasonable accommodation. So a reasonable accommodation is a statement that an individual needs for an adjustment or change in their work environment because of a medical condition. You don't need to state the specific words reasonable accommodation. You just need to make sure you're communicating to the agency that you need a workplace adjustment, workplace modification that's linked to a medical condition. Uh, the agency may require specific forms for you to complete a reasonable accommodation, but you obtaining a reasonable accommodation is not contingent upon you completing or filling out such forms. Again, the requirement is you make your employer, your supervisor, HR, reasonable accommodation office aware that you need an accommodation and you're linking that to a physical or mental impairment, a disability. So I provided some examples here. If an employee tells the supervisor, I'm having trouble getting to work at my scheduled start time because of my antidepressants I take, this could qualify as a reasonable accommodation request. Um, Whether or not the employee is entitled to the reasonable accommodation is subject to further analysis, but the agency should at least start the process to consider the request. Um, as far as what may not be a request for reasonable accommodation is you tell your employer or supervisor that you need a new chair because the one you have is uncomfortable. This is not a reasonable accommodation request because the employer or supervisor is not specifically aware that the request is being linked to a medical condition or a disability. So if you change this around and you say, well, I need a new chair because I have this medical condition related to my back, or I can't sit for long periods of time, because of this certain medical condition, that could be considered a reasonable accommodation request. And the agency is required to at least start the process. Again, that doesn't mean that the agency will guarantee that you'll get the accommodation, but they're at least required to start the process for the reasonable accommodation request. The reasonable accommodation process. So the employer is obligated to initiate discussion of a reasonable accommodation request when it's known that the employee has a disability, has reason to know that the employee is experiencing workplace problems because of the disability, or knows or has reason to know that disability prevents the employer from requesting an accommodation. So there has to be some notice to the employer, or the employer has to have reasonable belief that the employee has a disability that's interfering with their work. If, as far as telework, an employee says that I cannot work in the office um, for 5 days a week because of my medical issues, even if you're not filling a reasonable accommodation form, even if you haven't gone to the reasonable accommodation office, if you've told that to your supervisor, that should initiate the process for a reasonable accommodation. Um, and within that process, the employer should then speak with the appropriate parties, perhaps the reasonable accommodation office at your agency, perhaps human resources, to determine what the next steps are. Those next steps typically involve um, discovering what specific accommodation you're requesting and what is the basis of the accommodation. And the employers often will require or request medical documentation to support the disability that's requested. If you say you have medical issues related to getting into work, the employer is allowed to inquire into what those specific medical issues are. As we'll go to later, that inquiry needs to be limited to what your actual request is, but the employer is allowed to request information regarding the accommodation. There will be a meeting that the employer will request that to discuss the accommodation. This is called the interactive process, where the employer meets with the employee who's requesting the accommodation to discuss the accommodations and why the accommodation is needed. Um, then the employer will make a decision on whether the accommodation will be provided and provide the accommodation. Now, there is no specific time frame that the law provides for when an employer may or must provide an accommodation. However, the law does say, and case law does say, that the time limit for processing requests for and providing reasonable accommodations should be as short as possible. Often agencies have policies in place where they say that a reasonable accommodation request must be decided upon within 30 days or some time frame within their own internal policies. Certainly, if a reasonable accommodation request has not even been acknowledged, within a short amount of time, that could be an issue. In addition, even if an accommodation is granted but not provided, that could also be an issue that runs against the Rehabilitation Act. So, essential job function. So, we referenced this earlier. Essential job functions are the fundamental job duties of the employment position that the individual holds. So the employee must be able to perform unaided and or with the assistance of a reasonable accommodation the essential job functions. To determine whether a function is essential, there's several factors that are considered. Whether the position exists to perform a particular function, whether a function is essential and is the number of other employees available to perform that job function, or the degree of expertise and skill to perform the function. So, as far as that first factor, whether the position exists to perform a particular function, an example is if you're a proofreader, if your job is a proofreader, well, the essential function is for you to proofread documents. So that's an essential function of a job, of that job. As far as that second factor, whether essential function is essential, given the number of employees available to perform that function, well, if the employer only has so many employees that can perform the job functions of that position, that could be then considered an essential function of the position. If there's only a limited number of people that can perform the job, then that would make those job functions essential. Um, as far as the degree and expertise or skill required to perform the function, uh, if you think about this, this is perhaps like a professor, professor that has expertise or skill in their job. Their skills to be a professor or in their job functions as a professor are essential. Um, and I listed those, examples here, in this presentation, but again, when evaluating a reasonable accommodation request, and specific for telework, the first step or one of the first steps is at least looking to see what the essential job functions are. And as far as telework, it's, well, what job functions can be performed at home or away from the office, and what job functions can be performed or must be performed in the office. And specifically, what essential job functions can be performed away from the office. And so that's what the employer will be looking at when evaluating a reasonable accommodation request for telework. Next, a part of the analysis is the undue hardship analysis. So, if there is a reasonable accommodation that would permit an otherwise qualified individual with a disability to perform the essential functions of the position, the agency then must provide that accommodation unless it would impose an undue hardship on the operations of the agency. Um, it's the agency's burden to prove this undue hardship. It's a rigorous burden and must prove it convincingly. They must provide evidence of an undue hardship. For example, allowing a person to work from home would cause an undue hardship on my business because I need that person to be interacting with customers, and those customers must only be, we can only interact with customers face to face. Well, if an employer, asserts that and proves that only customers can be interacted with face to face in person, that could prove as an undue hardship. Alternatively, maybe there you could perform job functions at home, whether it be interacting with people, via virtually or whatnot. And so that could be a rebuttal to that argument regarding whether or not an essential job function would cause undue hardship on the employer. Um, the employer must conduct an individualized assessment as part of their undue hardship analysis. This means that the employer cannot just look at a position description and say, well, because the position description list that this function is essential and must be performed in the office, therefore your accommodation's denied. That would run afoul of the Rehabilitation Act and EEOC guidance. Rather, the employer should be conducting an individualized assessment of the circumstances regarding the employee to determine whether the specific accommodation would cause an undue hardship, significant difficulty, or expense. Um, and that assessment needs to be done individualized for each employee's reasonable accommodation request. Again, the analysis for telework is whether or not the essential job functions can be performed away from the office or at home. And the employer must conduct that individualized analysis to determine, well, can we adjust our work here to allow this person to perform their duties at home? There's some jobs that I think we could all say may be tougher to allow to perform from home. Perhaps a firefighter, or perhaps a police officer. It would be tough to have that job performed from home, and the employer may have a ability to prove an undue hardship, in that position. But there are other jobs, then the employer can make adjustments to allow that person to perform from home, especially in today's day and age with all the technology that we have to allow people to interact even from away from the office. Um, as far as requests for medical documentation, and I had mentioned this earlier, as far as an employer is entitled to request medical documentation from an employee to determine the nature of the disability and the need for the accommodation. However, like I mentioned, there are limitations. The employer can't exceed the bounds from what the reasonable accommodation request is based on, such as a generic request of provide me all medical documentation from last 10 years for any medical condition. That would be out of bounds for what the actual request is. In addition, the agency may not require the medical information to be provided from the physician. But it could still accept the information directly from the physician if the employee is desires, but it can't force the physician to provide the information directly. Um, like I said, the requests need to be tailored to both the individual's disability and the position in question. As far as and tailored means basically within a certain time frame specific to the condition being requested. I see a lot of questions always come up regarding this, and whether or not these types of requests violate any Privacy Act laws, HIPAA laws, and not necessarily so long as the requests are centered on the accommodation being requested. The agency is able to learn what the medical condition is. If an employee says that they have a condition, that impacts them coming into the office, and they must work from home, well, the employer is allowed per the law to learn what that condition is, what the diagnosis and prognosis is, to be able to evaluate that accommodation request. The employer can't learn of any other conditions that the employee may have. It's just the condition that's supporting the reasonable accommodation request. Um, so overall, we're talking about teleworking as an accommodation. And as we've discussed here today, an agency must allow an employee to work from home if an accommodation is needed and the essential job functions can be performed from home or away from the office, and it doesn't cause an undue hardship. Uh, the employer must modify its policy where work is performed if such a change is needed to grant the reasonable accommodation, but only if the accommodation doesn't provide an undue hardship. So this specifically depends on whether or not the essential job functions can be performed from home. And I have to see in cases that I've litigated that the employer doesn't really conduct this analysis. They look at the job description and they say, okay, well, this job description says this is an in-office position, therefore your accommodation is denied. And that is not the analysis. It's whether or not there could be adjustments that could be provided to the employee that don't cause an undue hardship. Whether we could allow the employee, even if the employee is a supervisor, perhaps, to work from home or to work away from the office, and they could still communicate with their clients, their customers, other employees they supervise virtually, and whether that would cause an undue hardship. Um, and we've talked about the undue hardship analysis earlier, but that's typically whether it causes undue expense, difficulty, performance could come into play in that as well, whether employees are performing well in their job. But the employer must, do provide an accommodation, must modify a policy, common practice, and not just look at a position description to determine whether that employee can perform work away from the office. Um, if there are other alternative accommodations that would be as effective, the employer can offer that. They're not required to grant the employee's accommodation to work from home if other alternative accommodations would be as effective to accommodate the medical condition. For example, transferring the employee to another location or facility that's closer to his or her home. That could be an alternative accommodation that could be as effective. Now, there could be further discussion on that point because an employer may say, well, I don't think it's effective. And that's when the employee needs to go back to their medical provider to say why this alternative work schedule or this alternative location does not help my disability, and make that known to the employer. But outside of providing that information, the employer can provide, that alternative accommodation. And we'll talk more about alternative accommodations in the next slide. Um, so an agency must identify and assess the effectiveness of all potential accommodations that would enable the individual to perform the essential job functions. So it's the agency could choose between any effective accommodations. It is not required to choose the employee's request for an accommodation to work from home. So, for example, an employee may request 5 days of telework, every day, telework. And the agency may say, well, as an alternative, we'll permit you to work 3 days of telework and ad hoc telework. And so the agency may say, well, we believe that's effective based on what you provided. Um, it's the onus on the employee then to say either they accept that offer or whether they don't agree to provide more information to say why that's not effective for their condition, for their disability. Um, again, alternative accommodations can be transferring the employee to another facility, changing the work schedule. Perhaps there's, a 4-10 schedule, 4 days a week, and then increase the hours of 10 hours per day. There's alternatives that are often um, offered to an employee for when they're requesting telework. And when that is offered, keep in mind that's still the ongoing interactive process. And so until there's an acceptance, an agreement between the agency and the employee, the interactive process is still continuing until that decision and that agreement is made. Um, as noted here, the agency is not obligated to create a new position for an individual with a disability. But if the accommodation that's being requested is not possible for that position, the agency must make a good faith effort to locate a vacant and funded position for which he or she is qualified. So, for example, sometimes there are situations where an employee must be working telework, permanently or fully, and that's not possible. And perhaps that's even agreed upon by the employee. And the only possible accommodation is requesting a new position, or transferring to a new position. So the agency is obligated to make a good faith effort to find and locate a vacant funded position. That will be in discussions with the employee as far as how far wide the search must be, whether it's at the same facility, whether it's in the nationwide, what positions the employee is willing to accept. That would be in discussion with the employee, and there's usually a certain time frame that the agency will conduct that search. And these are positions for which the employee must be qualified to perform and that are vacant. So those are alternative accommodations that could be provided if teleworking or another accommodation is not possible. As far as challenging a reasonable accommodation decision, so when a decision is made on an accommodation, the employee may not be agreeable. If it's a request for telework and the employer has denied telework but offered an alternative work schedule and the employee is not agreeable, well, there is a process to request reconsideration of the decision. Typically, the decision is made by the reasonable accommodation office and signed off by the supervisor. And most agencies have a policy in place that if the employee disagrees, they could challenge that decision through requesting reconsideration, and a second line supervisor will make the decision. Um, if that fails or if that process is not in place, then there are routes to file EEO complaints or grievances. An EEO complaint is a complaint alleging disability discrimination based on failure to accommodate. And that complaint will be filed with the agency's EEO office. which they would conduct counseling and possibly an investigation to try to resolve the issue. There could also be a grievance filed, whether you're part of a union or not. There could be a grievance filed through your collective bargaining agreement or even through an administrative process if your agency allows that. That process would be to challenge the reasonable accommodation decision and request that the accommodation be overturned. And there are usually with the grievance process, first steps and second steps processes. So it's just not considered by the person that's already denied the accommodation, but considered by other officials. Another route to challenge it is to propose alternative accommodations. If the employer has denied the accommodation outright, that doesn't stop you from requesting another accommodation, but for perhaps a different type of accommodation. Or if the employer has only offered an alternative accommodation that's not agreeable, well, again, like we discussed earlier, you should go back and say you don't agree, and say, what alternative accommodations actually would work. And I would suggest getting medical documentation to show the alternative accommodations that weren't provided will not be effective for the accommodation, but this is the accommodation that's necessary to propose an alternative. Um, that was a synopsis of our reasonable accommodations seeking telework. And I know that's a lot of information, but I hope that was helpful. We'll go ahead and look for any questions, that we have here.
If anybody has any questions, please submit those in the chat and I'll send them over to Michael and he'll answer them as best as he can.
While we're waiting, I know there were some pre-submitted questions, and I will try to answer some of these as I can. One of the questions I saw was, is there a time frame for the agency to issue an accommodation, or how long the process? Like I said, there's not a specific time frame, but the process should be as short as possible. And so any lengthy delay is even as far as acknowledging the accommodation or providing an accommodation that's been granted could run afoul of the Reasonable Accommodation or the Rehabilitation Act. And always look to your agency policies as well, as there's usually an agency policy and a handbook that says how long an agency has to review and decide on a reasonable accommodation. A question that was pre-submitted as well was about waiting on a reassignment due to a reasonable accommodation. Should you be required to use your leave, paid leave, or leave without pay? And is that acceptable? Well, if you're unable to perform the position and you must be reassigned to be able to work, typically the agency will put you on administrative leave with pay. If it's not necessarily prohibited that you'll be required to use your leave in that interim period, either the agency will usually put you on administrative leave, or they'll put you in a position that you can perform work while the reassignment is accepted. But I would suggest in that situation to request, reimbursement of any leave or any payment that you've been required to use during that interim, because you're waiting on the agency to act and your accommodation has already been approved. Another question that was pre-submitted was, what do you do when a reasonable accommodation rep does not want to mediate like they're supposed to and side with management? Well, the reasonable accommodation rep is supposed to be a neutral. That person should not be siding with management, although they're advising management at the same time. But if you believe they're not being fair or impartial, I would encourage you to go to the EO office. A question that we've received is there any right on interim accommodations while a denial is being appealed? Yes, interim accommodations are accommodations that an employer could provide while a decision is being made on the actual accommodation. In the telework context, if the request is for telework for full time, and the employee just can't come into the office, an interim accommodation may be, well, we're going to assign you duties that you can perform from home in the interim. And that even after a denied accommodation, that is something that you could seek, especially if you are unable to perform the essential job functions with the accommodation with the current position. So yes, you can request an interim accommodation to perform different duties of the position. Another question is regarding reasonable accommodations in relation to workers' comp related injuries. Is it the same process? Not necessarily. Workers' comp is a different process trying to prove that you should be compensated for injuries that occur on the job. Reasonable accommodation process is really trying to prove that you need to be accommodated for your position because of a disability that you have, not necessarily tied to injuries that occurred on the job. Another question is, what if you already have a reasonable accommodation and your supervisor continues to refuse to implement it appropriately? Well, you need to make HR aware, the EO office aware, because then that means that the reasonable accommodation request is not actually being provided. And that could be in violation of the Rehabilitation Act. If you haven't already, make sure your supervisor knows what your reasonable accommodation is and state that this is not being implemented properly. And if that is not successful, then I would encourage you to inform the EEO office. Question we just received was, can an employer proactively put an employee on telework and refuse you to allow you to come back in person? Well, and this doesn't seem to be necessarily tied to a reasonable accommodation. However, an employee or an employer has the right to state where an employee does work. And I don't know the exact situation here, but if an employer is, can't have people work in person, and requires people to work from home, yes, that could happen. If that's a permanent situation, I would have more questions about that. As far as just requiring somebody to be working telework, I've seen that happen usually over a shorter amount of time because of some situation going on at the place of business. Otherwise, if there's no situation that's a permanent amount of time and there's no explanation, that would seem to be, unusual, where I would raise more questions regarding that instruction. And I'm just looking over to see if we have any further questions. One question we did get pre-submitted was, does the federal agency have to give an employee a reasonable accommodation if that employee is a remote worker? Well, if remote work, if that's not even tied to an accommodation, no. If the employer's already agreed to allow you to work remotely, then that doesn't require an accommodation. Now, if you're saying that you've requested telework while you're already confirmed to work remotely, well, the employer may be understanding, well, you don't need to be working telework given that your agreement is to work remotely. If you apply or obtain a new position, then you could reinstitute your reasonable accommodation requests for telework. So a question we just got in, I think this is a good question. If you've had a reasonable accommodation and then you get a new supervisor that disagrees with the approval, can that supervisor reevaluate an approved accommodation? Not necessarily. If your job hasn't changed, no. And if to the extent the supervisor is trying to do that, that could run afoul of the Rehabilitation Act. If there's a change in job, duties, organization, that could cause, an evaluation of a reevaluation of your reasonable accommodation. But if there's been no change to your position, even under a new supervisor, then no, especially if it's for telework. Now, I've seen that a situation arise when there is some change in position or organization status that could cause a supervisor to, further discuss the accommodation. But if there's been no change, there shouldn't be any change to your accommodation. And, the new supervisor could become aware of the accommodation because that's the new supervisor. But so long as there's no change, there shouldn't be any change to the accommodation. Let's see. A question we got pre-submitted was whether or not the manager has to explain the reasons for the denial with evidence. Yes, they must explain why in writing, stating why this is not possible. If they don't, ask them. If they still don't, then pursue the rights that I described in this presentation through the EO office or through a grievance. I'm not seeing any more questions come in. And Taylor, if we don't have any more questions, I think that will wrap it up here for today.
I believe those were all of the more general questions. Thank you everyone for joining today's presentation, and thank you, Michael, for presenting. A copy of this presentation was recorded and will be sent to all attendees following. I hope everyone has a good rest of their day.
Thank you.